Fair use is a legal doctrine that permits the unlicensed use of copyrighted material for certain purposes, such as criticism, commentary, news reporting, teaching, scholarship, or research. It's a balance between copyright protection and the public interest in the free flow of information and ideas. Whether a specific use qualifies as fair use is determined on a case-by-case basis, considering factors like the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for the copyrighted work. Fair use is a doctrine in United States law that permits limited use of copyrighted material without having to first acquire permission from the copyright holder. Fair use is one of the limitations to copyright intended to balance the interests of copyright holders with the public interest in the wider distribution and use of creative works by allowing as a defense to copyright infringement claims certain limited uses that might otherwise be considered infringement. The U.S. fair use doctrine is generally broader than the fair dealing rights known in most countries that inherited English common law. The fair use right is a general exception that applies to all different kinds of uses with all types of works. In the U.S., fair use right/exception is based on a flexible proportionality test that examines the purpose of the use, the amount used, and the impact on the market of the original work. The doctrine of fair use originated in common law during the 18th and 19th centuries as a way of preventing copyright law from being too rigidly applied and stifling the very creativity which copyright law is designed to foster. Though originally a common law doctrine, it was enshrined in statutory law when the U.S. Congress passed the Copyright Act of 1976. The U.S. Supreme Court has issued several major decisions clarifying and reaffirming the fair use doctrine since the 1980s, the most recent being in the 2021 decision Google LLC v. Oracle America Incorporated. 1. Purpose and character of the use. The first factor is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. To justify the use as fair, one must demonstrate how it either advances knowledge or the progress of the arts through the addition of something new. In the 1841 copyright case Folsom v. Marsh, Justice Joseph Story wrote, "A reviewer may fairly cite largely from the original work, if his design be really and truly to use the passages for the purposes of fair and reasonable criticism. On the other hand, it is as clear, that if he thus cites the most important parts of the work, with a view, not to criticize, but to supersede the use of the original work, and substitute the review for it, such a use will be deemed in law a piracy." A key consideration in later fair use cases is the extent to which the use is transformative. In the 1994 decision Campbell v. Acuff-Rose Music Inc., the U.S. Supreme Court held that when the purpose of the use is transformative, this makes the first factor more likely to favor fair use. Before the Campbell decision, federal Judge Pierre Laval argued that transformativeness is central to the fair use analysis in his 1990 article, Toward a Fair Use Standard. Blanche v. Coons is another example of a fair use case that focused on transformativeness. In 2006, Jeff Koons used a photograph taken by commercial photographer Andrea Blanche in a collage painting. Koons appropriated a central portion of an advertisement she had been commissioned to shoot for a magazine. Koons prevailed in part because his use was found transformative under the first fair use factor. The Campbell case also addressed the subfactor mentioned in the quotation above, whether such use is of a commercial nature or is for nonprofit educational purposes. In an earlier case, Sony Corp of America v. Universal City Studios Incorporated, the Supreme Court had stated that every commercial use of copyrighted material is presumptively unfair. In Campbell, the court clarified that this is not a hard evidentiary presumption and that even the tendency that commercial purpose will weigh against a finding of fair use, will vary with the context. The Campbell court held that hip-hop group 2 Live Crew's parody of the song "Oh, Pretty Woman" was fair use, even though the parody was sold for profit. Thus, having a commercial purpose does not preclude a use from being found fair, even though it makes it less likely. Likewise, the non-commercial purpose of a use makes it more likely to be found a fair use, but it does not make it a fair use automatically. For instance, in L.A. Times v. Free Republic, the court found that the non-commercial use of Los Angeles Times content by the Free Republic website was not fair use, since it allowed the public to obtain material at no cost that they would otherwise pay for. Richard Story similarly ruled in Code Revision Commission and State of Georgia v. Public.resource.org, Inc. that despite the fact that it is a nonprofit and did not sell the work, the service profited from its unauthorized publication of the official Code of Georgia annotated because of the attention, recognition, and contributions it received in association with the work. Another factor is whether the use fulfills any of the preamble purposes, also mentioned in the legislation above, as these have been interpreted as illustrative of transformative use. In determining that Prince's appropriation art could constitute fair use and that many of his works were transformative fair uses of Carrio's photographs, the Second Circuit in Carrio v. Prince, 714 F.3d 694, 2d. Sir 2013, shed light on how transformative use is determined. What is critical is how the work in question appears to the reasonable observer, not simply what an artist might say about a particular piece or body of work. The district court's conclusion that Prince's work was not transformative is partly based on Prince's deposition testimony that he doesn't really have a message, and that he was not trying to create anything with a new meaning or a new message. However, the artist's intended message is not dispositive. Instead, the focus of the transformative use inquiry is how the artworks will reasonably be perceived. The transformativeness inquiry is a deceptively simple test to determine whether a new work has a different purpose and character from an original work. However, courts have not been consistent in deciding whether something is transformative. For instance, in Seltzer v. Green Day Incorporated, 725 F.3d 1170, 9th Sir 2013, the court found that Green Day's use of Seltzer's copyrighted Scream icon was transformative. The court held that Green Day's modifications to the original Scream icon conveyed new information and aesthetics from the original piece. Conversely, the Second Circuit came to the opposite conclusion in a similar situation in Andy Warhol Foundation for the Visual Arts Incorporated v. Goldsmith, 11 F.4th 26, 2d. Sir 2021. In that case, the Warhol Foundation sought a declaratory judgment that Warhol's use of one of Goldsmith's celebrity photographs was fair use. The court held that Warhol's use was not transformative because Warhol merely imposed his own style on Goldsmith's photograph and retained the photograph's essential elements. 2. Nature of the copyrighted work. Although the Supreme Court has ruled that the availability of copyright protection should not depend on the artistic quality or merit of a work, fair use analyses consider certain aspects of the work to be relevant, such as whether it is fictional or non-fictional. To prevent the private ownership of work that rightfully belongs in the public domain, facts and ideas are not protected by copyright, only their particular expression or fixation merits such protection. On the other hand, the social usefulness of freely available information can weigh against the appropriateness of copyright for certain fixations. The Zapruder film of the assassination of President Kennedy, for example, was purchased and copyrighted by Time magazine. Yet its copyright was not upheld, in the name of the public interest, when Time tried to enjoin the reproduction of stills from the film in a history book on the subject in Time Inc. v. Bernard Geiss Associates. In the decisions of the Second Circuit in Salinger v. Random House 24 and in New Era Publications International v. Henry Holt & Co., the aspect of whether the copied work has been previously published was considered crucial, assuming the right of the original author to control the circumstances of the publication of his work or preference not to publish at all. However, Judge Pierre N. Laval views this importation of certain aspects of France's droit moral d'artiste, moral rights of the artist, into American copyright law as bizarre and contradictory because it sometimes grants greater protection to works that were created for private purposes that have little to do with the public goals of copyright law, than to those works that copyright was initially conceived to protect. This is not to claim that unpublished works, or, more specifically, works not intended for publication, do not deserve legal protection, but that any such protection should come from laws about privacy, rather than laws about copyright. The statutory fair use provision was amended in response to these concerns by adding a final sentence: the fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. 3. Amount and substantiality. The third factor assesses the amount and substantiality of the copyrighted work that has been used. In general, the less that is used in relation to the whole, the more likely the use will be considered fair. Using most or all of a work does not bar a finding of fair use. It simply makes the third factor less favorable to the defendant. For instance, in Sony Corp of America v. Universal City Studios Incorporated, copying entire television programs for private viewing was upheld as fair use, at least when the copying is done for the purposes of time shifting. In Kelly v. Ariba Soft Corporation, the Ninth Circuit held that copying an entire photo to use as a thumbnail in online search results did not even weigh against fair use, if the secondary user only copies as much as is necessary for his or her intended use. However, even the use of a small percentage of a work can make the third factor unfavorable to the defendant, because the substantiality of the portion used is considered in addition to the amount used. For instance, in Harper and Row v. Nation Enterprises, the U.S. Supreme Court held that a news article's quotation of fewer than 400 words from President Ford's 200,000-word memoir was sufficient to make the third fair use factor weigh against the defendants, because the portion taken was the heart of the work. This use was ultimately found not to be fair. 4. Effect upon work's value. The fourth factor measures the effect that the allegedly infringing use has had on the copyright owner's ability to exploit his original work. The court not only investigates whether the defendant's specific use of the work has significantly harmed the copyright owner's market, but also whether such uses in general, if widespread, would harm the potential market of the original. The burden of proof here rests on the copyright owner, who must demonstrate the impact of the infringement on commercial use of the work. For example, in Sony Corp v. Universal City Studios, the copyright owner, Universal, failed to provide any empirical evidence that the use of Betamax had either reduced their viewership or negatively impacted their business. In Harper and Row, the case regarding President Ford's memoirs, the Supreme Court labeled the fourth factor the single most important element of fair use, and it has enjoyed some level of primacy in fair use analyses ever since. Yet the Supreme Court's more recent announcement in Campbell v. Acufros Music Inc. that all four factors are to be explored, and the results weighed together, in light of the purposes of copyright, has helped modulate this emphasis in interpretation. In evaluating the fourth factor, courts often consider two kinds of harm to the potential market for the original work. First, courts consider whether the use in question acts as a direct market substitute for the original work. In Campbell, the Supreme Court stated that when a commercial use amounts to mere duplication of the entirety of the original, it clearly supersedes the object of the original and serves as a market replacement for it, making it likely that cognizable market harm to the original will occur. In one instance, a court ruled that this factor weighed against a defendant who had made unauthorized movie trailers for video retailers, since his trailers acted as direct substitutes for the copyright owner's official trailers. Second, courts also consider whether potential market harm might exist beyond that of direct substitution, such as in the potential existence of a licensing market. This consideration has weighed against commercial copy shops that make copies of articles in course packs for college students, when a market already existed for the licensing of course pack copies. Courts recognize that certain kinds of market harm do not negate fair use, such as when a parody or negative review impairs the market of the original work. Copyright considerations may not shield a work against adverse criticism. Additional factors. As explained by Judge Laval, courts are permitted to include additional factors in their analysis. One such factor is acknowledgement of the copyrighted source. Giving the name of the photographer or author may help, but it does not automatically make a use fair. While plagiarism and copyright infringement are related matters, they are not identical. Plagiarism, using someone's words, ideas, images, etc. without acknowledgement, is a matter of professional ethics, while copyright is a matter of law, and protects exact expression, not ideas. One can plagiarize even a work that is not protected by copyright, for example by passing off a line from Shakespeare as one's own. Conversely, attribution prevents accusations of plagiarism, but it does not prevent infringement of copyright. For example, reprinting a copyrighted book without permission, while citing the original author, would be copyright infringement but not plagiarism. Procedure and practice. The U.S. Supreme Court described fair use as an affirmative defense in Campbell v. Acufrose Music Incorporated. This means that in litigation on copyright infringement, the defendant bears the burden of raising and proving that the use was fair and not an infringement. Thus, fair use need not even be raised as a defense unless the plaintiff first shows, or the defendant concedes, a prima facie case of copyright infringement. If the work was not copyrightable, the term had expired, or the defendant's work borrowed only a small amount, for instance, then the plaintiff cannot make out a prima facie case of infringement, and the defendant need not even raise the fair use defense. In addition, fair use is only one of many limitations, exceptions, and defenses to copyright infringement. Thus, a prima facie case can be defeated without relying on fair use. For instance, the Audio Home Recording Act establishes that it is legal, using certain technologies, to make copies of audio recordings for non-commercial personal use. Some copyright owners claim infringement even in circumstances where the fair use defense would likely succeed, in hopes that the user will refrain from the use rather than spending resources in their defense. Strategic lawsuit against public participation, SLAP, cases that allege copyright infringement, patent infringement, defamation, or libel may come into conflict with the defendant's right to freedom of speech, and that possibility has prompted some jurisdictions to pass anti-SLAP legislation that raises the plaintiff's burdens and risk. Although fair use ostensibly permits certain uses without liability, many content creators and publishers try to avoid a potential court battle by seeking a legally unnecessary license from copyright owners for any use of non-public domain material, even in situations where a fair use defense would likely succeed. The simple reason is that the license terms negotiated with the copyright owner may be much less expensive than defending against a copyright suit, or having the mere possibility of a lawsuit threaten the publication of a work in which a publisher has invested significant resources. Fair use rights take precedence over the author's interest. Thus the copyright holder cannot use a non-binding disclaimer, or notification, to revoke the right of fair use on works. However, binding agreements such as contracts or license agreements may take precedence over fair use rights. The practical effect of the fair use doctrine is that a number of conventional uses of copyrighted works are not considered infringing. For instance, quoting from a copyrighted work in order to criticize or comment upon it or teach students about it, is considered a fair use. Certain well-established uses cause few problems. A teacher who prints a few copies of a poem to illustrate a technique will have no problem on all four of the above factors, except possibly on amount and substantiality, but some cases are not so clear. All the factors are considered and balanced in each case. A book reviewer who quotes a paragraph as an example of the author's style will probably fall under fair use even though they may sell their review commercially, but a non-profit educational website that reproduces whole articles from technical magazines will probably be found to infringe if the publisher can demonstrate that the website affects the market for the magazine, even though the website itself is non-commercial. Fair use is decided on a case-by-case basis, on the entirety of circumstances. The same act done by different means or for a different purpose can gain or lose fair use status. Fair use in particular areas. Computer code. The Oracle America Incorporated v. Google Incorporated case revolves around the use of application programming interfaces, APIs, used to define functionality of the Java programming language, created by Sun Microsystems and now owned by Oracle Corporation. Google used the APIs definition and their structure, sequence, and organization, SSO, in creating the Android operating system to support the mobile device market. Oracle had sued Google in 2010 over both patent and copyright violations, but after 2 cycles, the case matter was narrowed down to whether Google's use of the definition and SSO of Oracle's Java APIs, determined to be copyrightable, was within fair use. The Federal Circuit Court of Appeals has ruled against Google, stating that while Google could defend its use in the nature of the copyrighted work, its use was not transformative, and more significantly, it commercially harmed Oracle as they were also seeking entry to the mobile market. However, the U.S. Supreme Court reversed this decision, deciding that Google's actions satisfy all 4 tests for fair use, and that granting Oracle exclusive rights to use Java APIs on mobile markets would interfere with, not further, copyright's basic creativity objectives. Documentary films. In April 2006, the filmmakers of the Loose Change series were served with a lawsuit by Jules and Gideon Nodet over the film's use of their footage, specifically footage of the firefighters discussing the collapse of the World Trade Center. With the help of an intellectual property lawyer, the creators of Loose Change successfully argued that a majority of the footage used was for historical purposes and was significantly transformed in the context of the film. They agreed to remove a few shots that were used as B-roll and served no purpose to the greater discussion. The case was settled and a potential multimillion-dollar lawsuit was avoided. This film is not yet rated also relied on fair use to feature several clips from copyrighted Hollywood productions. The director had originally planned to license these clips from their studio owners but discovered that studio licensing agreements would have prohibited him from using this material to criticize the entertainment industry. This prompted him to invoke the fair use doctrine, which permits limited use of copyrighted material to provide analysis and criticism of published works. File sharing. In 2009, fair use appeared as a defense in lawsuits against file sharing. Charles Nesson argued that file sharing qualifies as fair use in his defense of alleged file sharer Joel Tenenbaum. Kiwi Camara, defending alleged file sharer Jamie Thomas, announced a similar defense. However, the court in the case at bar rejected the idea that file sharing is fair use. Internet publication. A U.S. court case from 2003, Kelly v. Ariba Soft Corp., provides and develops the relationship between thumbnails, inline linking, and fair use. In the lower district court case on a motion for summary judgment, Aribasoft's use of thumbnail pictures and inline linking from Kelly's website in Aribasoft's image search engine was found not to be fair use. That decision was appealed and contested by Internet rights activists such as the Electronic Frontier Foundation, who argued that it was fair use. On appeal, the Ninth Circuit Court of Appeals found in favor of the defendant, Aribasoft. In reaching its decision, the court utilized the statutory 4-factor analysis. First, it found the purpose of creating the thumbnail images as previews to be sufficiently transformative, noting that they were not meant to be viewed at high resolution as the original artwork was. Second, the photographs had already been published, diminishing the significance of their nature as creative works. Third, although normally making a full replication of a copyrighted work may appear to violate copyright, here it was found to be reasonable and necessary in light of the intended use. Lastly, the court found that the market for the original photographs would not be substantially diminished by the creation of the thumbnails. To the contrary, the thumbnail searches could increase the exposure of the originals. In looking at all these factors as a whole, the court found that the thumbnails were fair use and remanded the case to the lower court for trial after issuing a revised opinion on July 7, 2003. The remaining issues were resolved with a default judgment after Aribasoft had experienced significant financial problems and failed to reach a negotiated settlement. In August 2008, Judge Jeremy Fogel of the Northern District of California ruled in Lentz v. Universal Music Corp. that copyright holders cannot order a deletion of an online file without determining whether that posting reflected fair use of the copyrighted material. The case involved Stephanie Lentz, a writer and editor from Gallitzin, Pennsylvania, who made a home video of her 13-month-old son dancing to Prince's song Let's Go Crazy and posted the video on YouTube. 4 months later, Universal Music, the owner of the copyright to the song, ordered YouTube to remove the video under the Digital Millennium Copyright Act. Lentz notified YouTube immediately that her video was within the scope of fair use, and she demanded that it be restored. YouTube complied after 6 weeks, rather than the 2 weeks required by the Digital Millennium Copyright Act. Lentz then sued Universal Music in California for her legal costs, claiming the music company had acted in bad faith by ordering removal of a video that represented fair use of the song. On appeal, the Court of Appeals for the Ninth Circuit ruled that a copyright owner must affirmatively consider whether the complaint of conduct constituted fair use before sending a takedown notice under the Digital Millennium Copyright Act, rather than waiting for the alleged infringer to assert fair use. 801 F.3d 1126, 9th Cir. 2015. Even if, as Universal urges, fair use is classified as an affirmative defense, we hold for the purposes of the DMCA fair use is uniquely situated in copyright law so as to be treated differently than traditional affirmative defenses. We conclude that because 17 U.S.C. 107 created a type of non-infringing use, fair use is authorized by the law and a copyright holder must consider the existence of fair use before sending a takedown notification under 512, c. In June 2011, Judge Philip Pro of the District of Nevada ruled in Righthaven v. Hone that the posting of an entire editorial article from the Las Vegas Review-Journal in a comment as part of an online discussion was unarguably fair use. Judge Pro noted that non-commercial, non-profit use is presumptively fair. Hone posted the work as part of an online discussion. This purpose is consistent with comment, for which 17 U.S.C. 107 provides fair use protection. It is undisputed that Hone posted the entire work in his comment on the website. Wholesale copying does not preclude a finding of fair use. There is no genuine issue of material fact that Hone's use of the work was fair and summary judgment is appropriate. On appeal, the Court of Appeals for the Ninth Circuit ruled that Righthaven did not even have the standing needed to sue Hone for copyright infringement in the first place. Professional communities. In addition to considering the 4 fair use factors, courts deciding fair use cases also look to the standards and practices of the professional community where the case comes from. Among the communities are documentarians, librarians, makers of open courseware, visual art educators and communications professors. Such codes of best practices have permitted communities of practice to make more informed risk assessments in employing fair use in their daily practice. For instance, broadcasters, cablecasters, and distributors typically require filmmakers to obtain errors and omissions insurance before the distributor will take on the film. Such insurance protects against errors and omissions made during the copyright clearance of material in the film. Before the documentary filmmaker's statement of best practices in fair use was created in 2005, it was nearly impossible to obtain errors and omissions insurance for copyright clearance work that relied in part on fair use. This meant documentarians had either to obtain a license for the material or to cut it from their films. In many cases, it was impossible to license the material because the filmmaker sought to use it in a critical way. Soon after the best practices statement was released, all errors and omissions insurers in the U.S. shifted to begin offering routine fair use coverage. Music sampling. Before 1991, sampling in certain genres of music was accepted practice and the copyright considerations were viewed as largely irrelevant. The strict decision against rapper Biz Markie's appropriation of a Gilbert O'Sullivan song in the case Grand Upright Music, Limited v. Warner Brothers. Records Inc. 47 changed practices and opinions overnight. Samples now had to be licensed, as long as they rose to a level of legally cognizable appropriation. This left the door open for the de minimis doctrine. For short or unrecognizable samples, such uses would not rise to the level of copyright infringement, because under the de minimis doctrine, the law does not care about trifles. However, 3 years later, the Sixth Circuit effectively eliminated the de minimis doctrine in the Bridgeport Music Incorporated v. Dimension Films case, holding that artists must get a license or do not sample. The court later clarified that its opinion did not apply to fair use, but between Grand Upright and Bridgeport, practice had effectively shifted to eliminate unlicensed sampling. Parody. Producers or creators of parodies of a copyrighted work have been sued for infringement by the targets of their ridicule, even though such use may be protected as fair use. These fair use cases distinguish between parodies, which use a work in order to poke fun at or comment on the work itself, and satire, which comments on something else. Courts have been more willing to grant fair use protections to parodies than to satires, but the ultimate outcome in either circumstance will turn on the application of the 4 fair use factors. For example, when Tom Forsyth appropriated Barbie dolls for his photography project Food Chain Barbie, depicting several copies of the doll naked and disheveled and about to be baked in an oven, blended in a food mixer, and the like, Mattel lost its copyright infringement lawsuit against him because his work effectively parodies Barbie and the values she represents. In Rogers v. Koons, Jeff Koons tried to justify his appropriation of Art Rogers' photograph puppies in his sculpture String of Puppies with the same parody defense. Koons lost because his work was not presented as a parody of Rogers' photograph in particular, but as a satire of society at large. This was insufficient to render the use fair. In Campbell v. Acufrose Music Inc., the U.S. Supreme Court recognized parody as a potential fair use, even when done for profit. Roy Orbison's Acufrose Music had sued 2 Live Crew in 1989 for their use of Orbison's "Oh, Pretty Woman" in a mocking rap version with altered lyrics. The Supreme Court viewed 2 Live Crew's version as a ridiculing commentary on the earlier work, and ruled that when the parody was itself the product rather than mere advertising, commercial nature did not bar the defense. The Campbell Court also distinguished parodies from satire, which they described as a broader social critique not intrinsically tied to ridicule of a specific work and so not deserving of the same use exceptions as parody because the satirist's ideas are capable of expression without the use of the other particular work. A number of appellate decisions have recognized that a parody may be a protected fair use, including the 2nd, Leibovitz v. Paramount Pictures Corp., the 9th, Mattel v. Walking Mountain Productions, and the 11th Circuits, SunTrust Bank v. Houghton Mifflin Co. In the 2001 SunTrust Bank case, SunTrust Bank and the Margaret Mitchell estate unsuccessfully brought suit to halt the publication of The Wind Done Gone, which reused many of the characters and situations from Gone with the Wind but told the events from the point of view of the enslaved people rather than the slaveholders. The 11th Circuit, applying Campbell, found that The Wind Done Gone was fair use and vacated the district court's injunction against its publication. Cases in which a satirical use was found to be fair include Blanche v. Koons and Williams v. Columbia Broadcasting Systems. Text and data mining. The transformative nature of computer-based analytical processes such as text mining, web mining, and data mining has led many to form the view that such uses would be protected under fair use. This view was substantiated by the rulings of Judge Denny Chin in Authors Guild Incorporated v. Google Incorporated, a case involving mass digitization of millions of books from research library collections. As part of the ruling that found the book digitization project was fair use, the judge stated Google Books is also transformative in the sense that it has transformed book text into data for purposes of substantive research, including data mining and text mining in new areas. Text and data mining was subject to further review in Authors Guild v. Hathitrust, a case derived from the same digitization project mentioned above. Judge Harold Baer, in finding that the defendant's uses were transformative, stated that the search capabilities of the Hathitrust digital library have already given rise to new methods of academic inquiry such as text mining. there is a substantial body of fair use law regarding reverse engineering of computer software, hardware, network protocols, encryption, and access control systems. Social media. In May 2015, artist Richard Prince released an exhibit of photographs at the Gagosian Gallery in New York, entitled New Portraits. His exhibit consisted of screenshots of Instagram users' pictures, which were largely unaltered, with Prince's commentary added beneath. Although no Instagram users authorized Prince to use their pictures, Prince argued that the addition of his own commentary to the pictures constituted fair use, such that he did not need permission to use the pictures or to pay royalties for his use. One of the pieces sold for $90,000. With regard to the works presented by Painter, the gallery where the pictures were showcased posted notices that all images are subject to copyright. Several lawsuits were filed against Painter over the New Portraits exhibit. In 2024, Richard Prince and the galleries were ordered to pay $900,000 to the photographers. Fair dealing allows specific exceptions to copyright protections. The open-ended concept of fair use is generally not observed in jurisdictions where fair dealing is in place, although this does vary. Fair dealing is established in legislation in Australia, Canada, New Zealand, Singapore, India, South Africa, and the United Kingdom, among others. Fair Use Week is an international event that celebrates fair use and fair dealing. Fair Use Week was first proposed on a Fair Use Allies mailing list, which was an outgrowth of the Library Code of Best Practices capstone event, celebrating the development and promulgation of ARL's Code of Best Practices in fair use for academic and research libraries. While the idea was not taken up nationally, Copyright Advisor at Harvard University launched the first ever Fair Use Week at Harvard University in February 2014, with a full week of activities celebrating fair use. The first Fair Use Week included blog posts from national and international fair use experts, live fair use panels, fair use workshops, and a Fair Use Stories Tumblr blog, where people from the world of art, music, film, and academia shared stories about the importance of fair use to their community. The first Fair Use Week was so successful that in 2015 ARL teamed up with Courtney and helped organize the second annual Fair Use Week, with participation from many more institutions. ARL also launched an official Fair Use Week website, which was transferred from Pia Hunter, who attended the Library Code of Best Practices capstone event and had originally purchased the domain name fairuseweek.org. Thank you for watching this video.